Okay, we're going to go ahead and get started. My name is Liz Niles, and I am here with attorney Britt Burner. We are from Burner Law Group. We wanted to thank the Westhampton Free Library for allowing us to present. Today, Britt will be discussing the new power of attorney and what you need to know. Please keep in mind, if you have any questions at all throughout the webinar, there is a Q&A section on the bottom of your screen. I do see that currently someone has their hand raised. Being the platform that we are in, it is easier to answer questions directly through that Q&A format. So whether you're on a phone or a laptop or an iPad, there is a Q&A. You can go ahead and type that in. We'd be happy to answer those questions throughout the webinar. And at this point, I am going to pass it on over to Britt.
Great. Thank you, Liz. Hi, everyone. Thank you for joining us today as we're going to talk about New York State's new and we think improved power of attorney. So I'm going to start with very simply, what is a power of attorney? It's a document. At its very simplest state, it's a document. And it talks about who has the authority to do certain financial and business matters on your behalf, and who you're giving that authority to, who the backup is, and what the parameters of that authority are. So it's a very important document as an elder law attorney, as a trust and estates attorney, because not only are we worried about helping people plan for after their death and how their assets will be distributed, but we're looking at how are we going to make sure you're taken care of while you're still alive. And you may hit a point where you have a diminishing physical capacity or diminishing mental capacity, and both or either could make it difficult for you to handle certain business functions of your life. So for example, it could be something as simple as you have the mental capacity to know that your bills have to be paid and you have to write those checks, but it may be physically difficult for you to sign your name or to write out those checks. And therefore, if you have an agent under a power of attorney, they can do that for you. On the other extreme is somebody who, because of dementia, Alzheimer's, or some other medical condition, has no cognitive ability. So this person can't open their mail, see what the bills are, know to write out the checks and send them out. That is beyond their cognitive abilities. And the power of attorney document, if drafted properly, should handle both of those circumstances and everywhere in between. And so when we talk about the new power of attorney law, that's what we're talking about. We're talking about this document that's allowing somebody to assist you with financial matters. Now, it's very important to realize that this is a duplication of your powers. So most powers of attorney do not rely on incapacity. What I mean by that is I sign a power of attorney now, I have my agent sign it saying that they can act, and I give the document to a bank, the bank puts it on file, and not only can I now write checks on that account, but so can my agent. So I'm duplicating the power that I've given them. I've duplicated the power that I have myself and given it to them. I am not saying I'm incapacitated and I can't do this anymore. In some circumstances, we have what's called a springing power of attorney. And what that is a document that has certain conditions written into it that state that the document only becomes effective upon the occurrence of certain events. So for example, it could say, if I'm deemed incapacitated by 2 licensed physicians, then in that circumstance, that's the only time that this power of attorney becomes effective. We get very nervous with springing powers of attorney because while I understand that people don't want somebody else to be able to access their accounts or handle things for them while they can still do it themselves, I feel reluctant about asking a medical professional to make this kind of determination because the doctor may not want to get involved in whether or not you should be writing your checks or handling your bills. And if you can't meet the conditions, you could be stuck with no one to act. And so that's a really important thing when you have a springing power of attorney. if you are going to do it, that you make sure you're doing so in a way that it can actually be effectuated at some point in time. I'm going to give you some definitions of some terms that I'm going to be using today to understand what we'll be discussing. One is the principal. The principal is the person who is giving the power to someone else. So if I'm signing a power of attorney document saying that my agent can make decisions on my behalf, I'm the principal. The person I'm giving authority to is my agent. And I can name co-agents, 2 people to act at once. I can name 1 person and a successor agent that only starts acting if the first agent is completely unable to act. And I can put in certain succession rules. I could say, so-and-so is my agent under power of attorney, but if a certain condition happens, then they'll no longer be acting, and then my secondary agent can act on their behalf, on my behalf. So that's a principal and an agent. There is the ability to put a monitor on the document, which is a person who can monitor the actions of the power of attorney and can ask the agent under power of attorney to produce records and accountings if you want there to be a checkup on your agent. Most of our clients are naming family members as agents under power of attorney or a close friend. And usually if they want a checks and balance type situation, they'll name co-agents who can check on each other rather than name a monitor who would really have to be brought into the situation and isn't constantly monitoring. You can compensate your agent if you allow for that in the document, saying how they should be paid. Maybe it's an hourly rate, maybe it's an annual rate. You can determine that with your agent or on your own, and your agent will have to abide by it. And then the term revocation. A revocation of a power of attorney happens upon your death. So power of attorney is only in effect while you are alive. Or if you revoke it, in that you sign a document saying, I revoke the power of attorney dated this day, naming this person, and you follow the requirements of the statute that tell you that you have to serve and send to that agent that you're revoking, you have to give them notice. Because if you think about it, it makes sense. How can I have you as my agent and now you're not able to act, but I'm not telling you or putting you on notice that you can't act? So I have to tell you that you're no longer acting on my behalf so that you can stop acting. And maybe I think you're doing a bad job. Maybe I think there's someone who could do a better job. Or maybe it's just that you have a lot on your plate with your own life. And so I've decided to name somebody else, or we've decided it together. But that's how you would revoke it. And you would also send the revocation document to any bank or institution that had the document on file already. I'm going to also refer to the term durable. Every power of attorney document that we are discussing today is a durable power of attorney. Durable means that it's in effect when you sign it and that it remains in effect if you become incapacitated. And the history of that is that powers of attorney traditionally at the beginning were used in a business setting. And if you became incapacitated, you might not want somebody to act on your behalf any longer. You were really just sending them as a proxy on your behalf. So now all powers of attorney are deemed durable unless they specifically state that they are not. And again, that means it's in effect when you sign it and also after you become incapacitated. I'm going to give you some examples beyond the examples I gave before of what your power of attorney can do for you. But it's very important to notice that your power of attorney can only do for you the things that you list in the document. So for example, if you want your agent under power of attorney to be able to create a trust on your behalf, you need to specifically state in the document that they can create a trust on your behalf. And if it's not specifically listed in the document, the agent does not have that power. So it's very important as you're drafting up this document that you think forward to all of the different situations that may occur, especially if you're creating this document because you fear you might become incapacitated down the line. And you want to make sure your agent is going to have all the powers they need. Otherwise, it won't be helpful for them to have this document. A common misconception is that a spouse can act on behalf of another spouse, and so that if you are married, you do not need a power of attorney. This is not true. Each spouse can only act on their own behalf. If there are joint accounts, it's true that there's a certain amount of control that one of the joint account holders has over the entire account. But if somebody is going to act on behalf of an individual and sign on behalf of an individual, they need to have a power of attorney authorizing them to do so. So just because you have a spouse doesn't mean you don't need a power of attorney. Now, you can name your agent to be your spouse in the first instance, and so it will effectively make it so your spouse can act on your behalf, but you still need to have a properly signed power of attorney document. The power of attorney becomes really important, as I said, in elder law when we're worried about incapacity, we're worried about a lack of physical ability to handle your own affairs. And if you don't have a power of attorney and you don't have the ability to handle your affairs on your own, the downside is that you could end up in a court proceeding called a guardianship proceeding. And that's what we call it in New York. In other states, they use the term conservatorship. But then the court has its hands in your business and everything has to be done with court approval. And that can be extremely slow and limiting for an agent acting under power of attorney, like a family member, a spouse, a child, who you don't want to have to ask for permission for everything they do because it slows down how they can act on your behalf. We use the power of attorney document in Medicaid planning, either to protect assets, to move a house, a bank account, an annuity, whatever it may be, into a trust. We also use it in the home care setting. If somebody has excess income, meaning income above and beyond the amount Medicaid allows you to have, we can protect that income if that person creates what's called a pooled income trust, which is a topic for another day. But it's important to note in this conversation that your power of attorney should allow your agent to create such a trust on your behalf so that all of your income can be protected and the agent can manage it through the trust and use it to pay your bills. So it's very important. Also, when people have long-term care insurance, if a claim has to be made to the long-term care insurance company, the follow-up phone calls, whatever it may be, you want your agent to have the power to do that on your behalf so that things can get done, and you may be in the hospital or unable to wait on hold that long, and you want to make sure your agent has that authority and doesn't need you on the line with them. So now we're going to talk about what's changed, and the history of the power of attorney is important to see how we got here and what kind of changes are happening. So back in 2009 was the big change we saw to the power of attorney law. The New York State power of attorney is under the general obligations law. That's where it's created, and that's where the terms that govern the power of attorney are found. And in 2009, there was something added in that the document required now that the agent sign. So it's not enough for me to just sign giving you the power. You have to sign accepting the power. And also adding what's called a gifts rider. In 2009, it was called a major statutory gifts rider. There were some minor amendments to the document in 2010, and it was termed a statutory gifts rider. So from 2010 until just this past year, we have had the same power of attorney statute. And so documents were signed. The power of attorney was two documents. It was the power of attorney document. It had a section where you could initial that you've attached the statutory gifts rider, and then the gifts rider had to be attached. But it was very confusing for people because it was a rider that had to be signed at the same time the power of attorney was signed and had to be attached to it. So it wasn't truly a separate document. It was really part of the same document. Also confusing was that it had different signature requirements. So the power of attorney document had certain places to initial, and then you had to sign in front of a notary. And then the statutory gifts rider had places to initial, and then you had to sign in front of a notary and two witnesses. One of the witnesses could have been the notary. So there was different signing requirements, and it was creating a lot of confusion. It was very difficult for people to get valid powers of attorney signed because of this confusion. There was also what we call exact wording. So exact wording meant if you had even a word off from how the document was drafted in the statute, your entire document could be found invalid, even if that word was and or the. So it required exact wording. And so that created a problem. And the real problem with the power of attorney is if it is not effective, you may not find out until your agent tries to use it and you're at a point where you don't have the mental capacity to sign a new one. And then your agent is caught without anything and they're back in that guardianship proceeding. So it was really important to make a statute where people could have a valid document and rely on the fact that they had a valid document, because it's often not used until sometime in the future. So then from 2010 until recently, we had the same statute. And in December of 2020, a new power of attorney was signed into law. These were amendments to the general obligations law. And there was a comment period. And after a period by which we were waiting for it to come into effect, 180 days. And so on June 13th of 2021, just this past June 13th, we officially have a new power of attorney. It's very important to note that any power of attorney that you signed before June 13th should have been on the old form with the power of attorney and the statutory gifts rider. And anything signed on June 13th or later should be on the new document. So it's very important that now in 2021, post enactment of the law, that the document that you would sign new today be in accordance with the new law, not the old law. If you want to have what is called a statutory power of attorney, which is one that you have the ability to be the proponent of and the ability to force a bank or other institution to accept. So now that the date has passed, we're signing new documents with clients coming in. Now, your old documents are grandfathered in. So to the extent that you signed a power of attorney 6 months ago, a year ago, 2 years ago with your attorney, that is still, if it was valid when you signed it, it is still a valid document. However, we urge you to return to your attorney and to ask your attorney if you should update the document, because there's various factors that lead us to believe they should be updated. Factors in how they were executed, whether or not the agent has signed the document yet, and also just did the document, was it a full document that really met your needs? And this is a great time to review that document and check on it. A power of attorney does not require a lawyer be involved. However, I urge you to seek the assistance of a lawyer when creating the power of attorney document for several reasons. One is that, yes, you want to make sure you have the right form from the state, because in the end, the outline of the document, the bones of the document have been set forth in a statute. So it's very important that you make sure that it's valid on that front. Then there's a section called a modification section. And in that section is where we allow that gifting and certain opening of trusts and all of those things. And you want to make sure that the modifications made to the document will make it the best document for you. Again, should down the line you need somebody to act on your behalf. And so the modifications are not something that you'll find in the statute or you can do on your own. And so that's why I urge you to seek the assistance of an attorney when signing a document like this. I also think it's important to realize that attorneys don't just draft documents, they give advice. And I have many clients who, when we first talk about the power of attorney, they don't understand the reasoning why I would suggest certain powers be added in and be given to the agent. And it's for things that happen down the line that the client might not know of, such as Medicaid planning, as we discussed, certain issues with incapacity, with changing where you live, signing a contract for an assisted living or a nursing home. All of these things, which you might not think about because it's not in your day-to-day life yet, that may come up down the line that you would want your agent under power of attorney to be able to do for you. So I would just urge you to speak with your attorney about a valid power of attorney document. So what's new? We've started to talk about a few of the things. One, as I said, was that the document used to require exact wording. You couldn't be one word off from the statute. Now we have something with this new law called substantial compliance. So as long as the document substantially complies with the statute and it's clear what you're conferring, then it will be valid. I still would recommend keeping pretty strictly to the form that's created in the statute, but this allows for some error or some ambiguities or some changes that were not allowed in the prior document. There's also, now we're allowed to say that something is intentionally omitted. So for example, if I'm not naming a monitor in the document, I can now write intentionally omitted in that section to show I'm not doing it. Whereas before, I just had to leave a blank area that said that you appoint a monitor, but there was no name written in. And that was confusing for a lot of people. So now we can write in intentionally omitted. That statutory gifts rider that I talked about from 2010, that is gone. The statutory gifts rider is no longer a thing. The gifting provisions should now be added into the modification section of the document to the extent that you want to be able to gift. And gifting is not only charitable gifts, gifts to family members and friends, but it can also include transfers to trusts for the benefit of the individual, for the benefit of a family member, and any transfer of assets out of your name, even from one spouse to another. So it's important that if you are trusting of your agent and that you want your agent to have full authority down the line, that these gifting provisions are added into the modification section. Eliminating the gifts rider made it so now the agent, the principal, initials in certain places. They date and sign. They sign in front of two witnesses, one of which can also be a notary. So it's notarized and then it has two witnesses. And then the agent still signs in front of a notary. So it's cut down the amount of signatures that are necessary, but it took those two witnesses from the gift rider and it put it onto the main document. So that can be a little more difficult if you take the case of somebody who's giving a power of attorney, maybe to an attorney who's handling a real estate closing for them. Instead of just having that notarized, they now need a second witness as well. So that's important to realize, especially if you're doing powers of attorney, not as part of your estate planning, but for business and other purposes. They've increased the limit for family gifting and maintenance. So it used to be that anything over $500 that's being given away to family members would require that gift rider. Now gifting under $5,000 can be given if you don't give other gifting provisions. So let me give you an example. If I don't feel comfortable with my agent being able to transfer assets to trust or give money to themselves or anyone else, I might not add in all of those gifting modifications that we've been discussing. However, I might feel comfortable if it's clear that every year I give $100 to each of my grandchildren for their birthdays. I might want my agent to continue that type of gifting. Well, that's less than $5,000, so that can be done through my power of attorney without special gifting provisions. Another big change in how we sign the document, which is very excited for those with physical disabilities, stroke victims, ALS, others who have a physical disability and inability to sign the document, even though they cognitively are aware of what it is and want to sign it, is that now the statute allows for somebody to sign on that individual's behalf. So I had a client right after this law changed in June who we went and signed a power of attorney document with. She's unable to hold a pen in her hand because of a physical disability. So I signed the document on her behalf once she was able to vocally tell myself and the other two that were in the room with us that this was what she wanted to do. And we discussed the document. She made it clear that these were her wishes. I signed the document. I had one witness as a notary, and then the two witnesses each signed as witnesses. And she now has a valid power of attorney document under the new law signed by me. And it actually says her name, Britt Burner, on behalf of that woman's name. And that's how her power of attorney reads, to make it clear that I signed it on her behalf. But this is a really exciting thing, again, for those with physical disabilities, because now they can express the desire to have a power of attorney, have someone sign it for them, and not end up in a guardianship just because they can't sign the document. And we used to do things like X's and marks, but that was imperfect. So it being written into the law is a really huge deal, and we're really excited about that. The notarization of the agent's signature, I want to point out, is not time barred in any way. So I could sign it now, naming my agent to act, and my agent can sign it in 10 years when I become incapacitated and need them to act. There's nothing that says they have to sign in any short amount of time. That being said, what we have is an ambiguity in the law in terms of documents being grandfathered in. So we're asking through the Bar Association, we're hoping to ask the legislature to fix this ambiguity in the law. But as of right now, it stands. And that ambiguity is that if I signed a document 3 years ago, it was a valid power of attorney. It's unclear if it is still a valid power of attorney now that the law has changed, and if it's been grandfathered in, if my agent hadn't signed. Because technically the document is fully executed once the agent signs. And so that's a clarification that we're seeking from the legislature, and we're hoping to get more information on that. So stay tuned. And when I say we, I mean members of the New York State Bar Association. In terms of other changes in the statute, the big one is in terms of an institution accepting the document. So there's now a process in the statute for how a bank or other institution can go about reviewing and accepting the document. So if I am the agent under power of attorney and I need to act on behalf of the principal, I can sign and take this power of attorney to the bank, and I give it to them and I say, I'm the agent. This, my mother, let's say, is the principal, and I need to act on her behalf. They'll say, okay, we're sending it to legal. They can ask for an opinion letter of counsel of an attorney saying that this is a valid document. To their knowledge, it hasn't been revoked, etc. They have 10 days to review my request to have that document accepted by the bank. Then they write to me, and let's say they say, okay, we accept your document. Well, then my name goes on the account as power of attorney and I can sign on the account. If they say, no, we don't accept this as a valid power of attorney, I have as much time as I want to rebut that, to come back and say, no, you're wrong. It is power of attorney and it is valid for these reasons. They then are time barred to 7 days to come up with a final answer of whether or not that power of attorney document will be accepted or not. And they are required to deny or accept based on reasonable grounds. So if I find that they are being unreasonable in rejecting my document, then I can bring a court proceeding, a special proceeding, to enforce the power of attorney. And if they're found that they were unreasonable, and if I win, I now have the ability to charge fees against the bank and get my attorney's fees and damages back. So this is what we hope is some teeth in the law, so that those of you who maybe have had a power of attorney unreasonably rejected by a bank or other institution now have the ability to fight back. And it's in the statute, which gives it a lot more teeth and makes it a much better fight to be had. So to sum up, if you have an old power of attorney, it is still valid if it was valid when you signed it, but I would urge you to reach out to your attorney to review that document and review your other estate planning documents, because any change in the law is an excellent opportunity to review your plan and to make sure that things are up to date and that there's no additional information that you should be putting into your document or additional planning that should be done based on these changes in the law. So thank you everyone for joining. I'm going to take questions and answers now. So as Liz had said, down or on your computer, you'll see on the bottom of the screen, there is a chat box and it says Q&A. You could click on that and write a question in, and I'm happy to answer it.
Okay, we've got one question. I am having a power of attorney document prepared now. My husband would be my agent. I'm considering whether my 2 children should be listed as successor agents. What are the pros and cons of doing this? And when would my children have to sign the document?
Okay, great question. So your 2 children, part of it is in terms of having a successor or not having a successor. I always recommend that if you have successors that you can name, that you trust, and you feel comfortable giving this power to, then I would put them on the document. It's better to have a successor than not, because if your spouse can't act, you could end up in a situation where you essentially don't have a power of attorney, and then all this planning wasn't for any reason. Whether or not to put your children as successor agents will depend, one, on how do they work together, and then you'll have to determine if they can act together or if they can act separately. If they have to act together, that could be logistically difficult sometimes, especially if they live in different places or have different schedules, because it might be hard for them to make calls differently. But the real question is going to be, if you have a power of attorney document that you want to have your successor agents act together, you have to make sure that they both sign it. They will sign it in the instance that your spouse can't act. So you could have them sign it now, or you could wait and have them sign it at the time. But if there are going to be 2 of them listed as successor agents, the bank's probably going to require that they both sign it before it can be used by either one of them. And then the question is going to be, are they acting separately or are they acting together? Can they work well together? Do you want them to be able to delegate powers to each other? So these are the things that you should be thinking through as you're deciding whether or not to name them as agents. But really the real question is, do you feel comfortable that if something should happen to you and your spouse, that your 2 children would have access to all of your accounts and other information?
Thank you. I don't see another question, but we'll give a few seconds if anyone else has anything that comes up on that Q&A section. We'd be happy to answer that for you.
Great. And as we wait for that, I'll also point out that very often people contact me and they ask about a medical power of attorney. In New York State, we don't call it a medical power of attorney. We call it a healthcare proxy. So when I'm talking about a power of attorney under New York State law, as I said, it's the general obligations law, and it's for financial and business type affairs. If you want somebody to be able to make medical decisions on your behalf, that would be done through a healthcare proxy document. And that, unlike the power of attorney, states that the healthcare agent can only make decisions on your behalf if you are incapacitated as determined by a doctor. So your power of attorney could be acting on your behalf, signing checks, doing all these things, but your doctor may still say you can make your own medical decisions. So the healthcare proxy wouldn't yet be in effect. And again, if you have any questions, and I saw there were some raised hands, if you could write them into the Q&A so that we can answer those questions, I'd be happy to do so. Okay, so someone says, just to clarify, a springing POA is not recommended. I should say that all of these things that we're discussing today should be discussed with your own attorney according to your own circumstance. But for many clients, I don't like a springing power of attorney because I get very nervous, and I've seen it happen where we need the sign off from a doctor for the document to be effective, and I can't get the doctor sign off. And therefore, as we know, incapacity has a lot of gray area. So you might be in need of help, but not to the point where you're totally incapacitated, and therefore you don't have a valid document if it's springing and you don't have that. So I don't like the springing power of attorney for that purpose. That being said, I have done it for some clients who are not that comfortable with the idea of someone having access to their accounts. What I usually recommend is that you can sign the document now, and you tell the person you've named as agent where your documents are, and that if something should happen to you, that they can go get those documents, sign them in front of a notary, and then bring them to the institution that they want to honor it. So it's kind of a way of controlling it yourself without creating a situation where we need to inform the doctor or involve the doctor. It's asking if someone else asks if your power of attorney should be recorded at the county clerk office along with your last will and testament. So generally speaking, we don't have clients record either document, their last will and testament or their power of attorney. I'll take one at a time. With the power of attorney document, it's usually only recorded in the instance that there's let's say you're selling a property and you're signing by power of attorney, then the power of attorney gets recorded along with the new deed that you've signed to transfer the property. That's usually when a power of attorney is recorded. In terms of a last will and testament, you would put your last will and testament, if you put it on file anywhere, it would be in the surrogate's court of the county in which you lived. We often don't have people do that because we want you to have the opportunity to change your last will and testament at any point in time and not have to go running back and forth to the court for it. However, in limited circumstances, we have recommended that a last will and testament be put on file to make sure that the original is not destroyed if there's a specific concern, especially that somebody's going to come in and destroy the document and attempt to change your wishes for after death. There's another question: who decides if you are incapacitated? So it depends. It depends what you're looking to find it out about. So if it's whether or not you can make medical decisions, the doctor that you're speaking with will determine if they think that you can engage in the process with them of making medical decisions, and they determine if you're incapacitated. If I'm looking to sign documents with a client so that they can do their estate planning, then I will meet with the client and review things with them. And if I believe they have the capacity to understand what they're signing, well, then I'll sign those documents with them. And so it just depends on what it is. In terms of the springing power of attorney, it would be if the doctor will, usually the way it reads, it depends how you write it into the document, but it would usually read that if the doctor thinks that you're no longer able to manage your own financial affairs, then they say you're incapacitated. So it's going to depend on what what's the reason for deeming incapacity. Also, someone could be incapacitated one day and not the following day. You could have periods of lucidity. And so that's the other reason why the springing power of attorney makes me nervous, because if you have good days and bad days, you may need help some days and not others. And so you can't have that power of attorney document popping in and out. So that's why I generally say that. I also see a question here about the presentation being available. All of the presentations that we do, we can make available. So you can reach out to the library, to Nola Thacker at the Westhampton Beach Library, and she can assist you with getting finding how to look at the recording. Okay, so someone had their legal documents done about 20 years ago and then recorded them. They've now updated their documents and have not recorded them. I think that it would make sense to reach out to the county where those are recorded and find out their process for basically removing those from the file, or if it requires you to record your new ones, because you don't want that if your new ones can't be immediately located, that someone says, oh, look, these are on file and your old documents are followed when you didn't intend for them to be. Any other questions? Okay, great. Well, thank you everyone for joining us. I'm glad we had a little technical difficulty at the beginning, but we were able to work that out. So thank you for being patient. I hope you all have a wonderful day, and I'll speak with you soon.